And I'll just email myself the link to put on the website.
That would be perfect.
Cool.
Probably what people keep calling about.
Probably.
Just not answering. They can
That's
leave me a
one.
voicemail and I'll call them back.
That's
but-
one way of doing it.
I already emailed them saying it would be public.
Oh, shoot. And I'll just
Now,
Okay, all right. Can everybody hear me now? Okay, great. Are we ready to go ahead and go on the record? I see a head nod. I see a couple head nods. Okay. All right, we'll go ahead and go on the record. This is case number 822-000704, Women's Medical Group Professional Corporation and Planned Parenthood Southwest Ohio Region versus Bruce Vanderhoff and the Ohio Department of Health. We are here for a preliminary injunction hearing. If the parties could just go ahead and unmute yourself one at a time and identify yourself for the record, that would be appreciated.
Good morning, Your Honor. Elizabeth Watson for the plaintiffs, representing Women's Med Dayton and the trial attorney for this case.
Thank you.
Good morning, Your Honor. Melissa Cohen for the Planned Parenthood plaintiff.
Good morning, Your Honor. Jessie Hill for the plaintiff, Women's Med Dayton.
Good morning, Your Honor. Amy Gilbert on behalf of plaintiff, Women's Med Dayton.
And Virginia Mary on behalf of plaintiff, Women's Med Dayton.
Good morning. This is Rachel Reeves for plaintiff, Women's Med Dayton.
Morning, Your Honor. This is Kyla Eastling for plaintiff, Women's Med Dayton.
Good morning, Your Honor. This is Amanda Narog on behalf of defendants Bruce Vanderhoff and the Ohio Department of Health.
And good morning, Your Honor. Fernand Rucker here in the courtroom on behalf of Planned Parenthood.
Okay, thank you. We do have one of the plaintiff's attorneys here present physically in the courtroom. Everybody else is appearing via Zoom video conference. Is that everybody? Speak now or forever hold your peace, so to speak. Okay. All right. So I think we've identified everyone for the record. This is a plaintiff's motion, so I'll go ahead and let the plaintiff begin argument. And I'm assuming it's Ms. Watson who's going to be arguing today.
Yes, Your Honor.
Okay.
Your Honor, this court needs to continue to enjoin defendants from carrying out enforcement that now even they concede is unlawful. Without a preliminary injunction, defendants will pick up where they left off before this court entered a TRO and revoke plaintiff's license. We've asked defendants several times to agree to an order to require them to act consistent with the law. They refuse to do so. Instead, they continue to argue that they can revoke or refuse to renew plaintiff's license at any time for any reason, including noncompliance with SB 157. Thus, it is necessary for this court to enter a preliminary injunction to prevent them from doing so. Plaintiff's arguments have not changed since the TRO. By its own terms, SB 157 cannot be enforced against plaintiffs until 90 days after the effective date of the law. That is June 21st, 2022. That is over 2 months from now. On that, the parties agree. Enforcing SB 157 before that date to revoke or refuse to renew plaintiff's ASF license would be a blatant violation of plaintiff's due process rights. Defendants have absolutely no justification for this premature enforcement. Instead, defendants' brief primarily focuses on getting this matter away from this court, but defendants' jurisdiction and venue arguments must fail. This court has a duty to vindicate constitutional rights. That includes preventing the deprivation of plaintiff's property and liberty interests without due process. The administrative court does not and cannot vindicate those rights, and as described in the complaint, the law at issue stands to injure both plaintiffs, Planned Parenthood and Women's Med Dayton. Planned Parenthood is located in Hamilton County. Thus, this court has jurisdiction and is the appropriate venue. Without an injunction, plaintiff will be subject to serious constitutional, business, and other harms, and plaintiff's patients will face constitutional harms as well as harms to their health and well-being by being denied access to constitutionally protected, time-sensitive health care. This court should act today to enjoin defendants' premature enforcement of SB 157 and prevent this irreparable harm. I welcome the court's questions.
Okay. I don't have any questions at this point. I might, but I'll go ahead and give the defendant an opportunity to respond. whenever you're ready.
Thank you, Your Honor. I understand that the issues raised in this case are a bit of a hot button, but the Dayton Clinic, has brought claims that are not ripe for this court's consideration. The Dayton Clinic cannot use a declaratory judgment action to avoid the regulatory process provided to it under Ohio law for challenging a proposed revocation of an ASF license. The essential elements for declaratory relief are a real controversy existing between the parties. The controversy is justiciable in character and speedy relief is necessary. The question here is, does the Dayton Clinic have a justiciable claim? Because it has chosen not only to initiate a declaratory judgment action, but has also decided to circumvent the administrative process entirely, it does not. The Ohio Supreme Court recognized in Capital Care Network of Toledo that the General Assembly made a policy decision to vest the authority to license ambulatory surgical facilities in the Ohio Department of Health and in defining the scope of judicial review of its decisions. The Dayton Clinic cannot challenge the variance denial in this or any other court. The plain text of 3702.3011 provides that the director may at any time rescind the variance for any reason, including a determination by the director that the facility is failing to meet one or more of the conditions or no longer adequately protects public health and safety. The director's decision to rescind a variance is final. The General Assembly has vested that authority to consider, grant, deny, and revoke variances solely in the director of ODH, and such determinations are allowed for any reason. If the loss of a variance leads to a subsequent revocation of an ASF license, then the license revocation may be appealed pursuant to 119.12, and the courts then have jurisdiction to review the agency order. This court does not have jurisdiction to consider the variance denial at all, nor does it have jurisdiction to review the proposed license revocation because it is not a final order subject to the court's review. And even if it were, 119.12 provides that such appeal must be made in the common pleas court in which the business of the licensee is located, or the county in which the licensee is a resident, both of which require the appeal to be filed in Montgomery County Common Pleas Court. This court then cannot grant the relief that the Dayton Clinic seeks. The standard of review for appealing the standard of review to appeal to a common pleas court from an administrative order revoking or denying renewal of a license is contained in 119.12, which specifies that the order should be affirmed if it is supported by reliable, probative, and substantial evidence and in accordance with law. Without a full venting of the administrative remedies, there cannot be an enforceable right, as Ohio requires exhaustion of administrative remedies. But even if this court had jurisdiction to hear this case, because the Dayton Clinic avoided the administrative process entirely, there's no record or evidence for this court to review, which frustrates the statutory scheme and that was provided by the legislature. The Dayton Clinic frames its claim as a declaratory judgment action, not an administrative appeal, but it does not change the substance of this case. The Dayton Clinic asks the court to second guess a variance decision, and that is a decision that the legislature has reserved to the director, not the courts. When a special statutory proceeding for review of a matter exists, a litigant may not bypass that proceeding by seeking a declaratory judgment and injunction. It is well established under Ohio law that prior to seeking court action in an administrative matter, the party must exhaust available avenues of administrative relief through administrative appeal. Exhaustion is required generally to prevent premature interference with the agency process so that the agency may function efficiently and have the opportunity to correct its own errors, to afford the parties and the court the benefits of the agency's expertise and experience, and to compile a record adequate for judicial review. Even if the director had no independent or plenary authority to deny a variance for any reason, the Dayton Clinic failed to make that argument in the pre-enforcement of Senate Bill 157 in a hearing with the director or his proxy, preventing any attempt to correct or provide a proper determination for the reasons to renew or deny the license of Dayton's ASF. That is information this court needs to properly consider if such decisions are reasonable or lawful. The constitutional claims here could have been argued and preserved during the administrative hearing. On appeal, those arguments could have been decided by the Montgomery County Court. And while it is true that constitutional challenges on its own are subject to declaratory judgment action, even absent administrative exhaustion, In an as-applies challenge like this one, the factual record must be developed through the administrative process if the constitutional challenge is subject to be reviewed by this court. The Dayton Clinic claims that the administrative process would amount to a vain act. The exhaustion, therefore, is not necessary, but that misunderstands the exception. Futility in this context means not that the administrative agency would not grant the requested relief, but that the administrative agency lacks the authority or power to grant the relief, and the hearing available to the Dayton Clinic would have been before the director or his representative, who holds total authority to grant the relief sought here. Importantly, futility is not a jurisdictional exception. It is only an exception to exhaustion. It cannot supplant the statutorily provided procedure for review of the proposed license revocation. Regarding the motion for preliminary injunction at bar, the Dayton Clinic cannot show that it is substantially likely to succeed on the merits of its claims. The Sixth Circuit in Planned Parenthood v. Hodges held that Ohio may refuse to subsidize abortion services, just as the federal government has done through the Hyde Amendment. The amendment to Senate Bill 157 here does this very thing. Ohio has made the policy decision to effect a strict separation between state and abortion. It is perfectly constitutional to prevent a doctor cloaked in state authority as affiliated with a state medical school from acting as a consulting physician for abortion clinics. This is not an onerous or constitutionally offensive position. And critically, the Hodges case categorically stated that abortion providers do not have a constitutional right to perform abortions. The only circuit that has made such a determination did so pre-Casey, and the Hodges court noted that it did no meaningful analysis of the authorities, while several other circuits have reached the exactly opposite conclusion. Hodges also determined that third-party standing cannot fill the gap because even if the Dayton Clinic could advance its patients' claims, the case law does not establish that the clinics have a due process right themselves. But as the Ohio Supreme Court has made plain in this context, the court need not reach constitutional issues unless necessary to decide the case, which is true here. The statutory scheme provides for another authority to review this matter, and it can be determined by the regulatory and statutory rules there. And such determination only then can vest the Common Pleas Court with jurisdiction to consider these claims, if at all. Senate Bill 157 is a proper regulation of ambulatory surgical facilities and does not implicate the rights of the Dayton Clinic's patients. The Sixth Circuit in Baird found that having to travel further to obtain an abortion is not an undue burden, and the Dayton and Cincinnati Clinic concede that Columbus and Cincinnati will continue to provide abortion care, even if Dayton does not. If an otherwise constitutional regulation is the reason a clinic loses its ASF, it does so lawfully and does not offend any constitutionally protected rights, because the rights raised here are subject to such regulation. For these reasons, the court should deny the preliminary injunction motion.
Thank you. Any response, Ms. Watson?
Yes, Your Honor. So I just want to point out for the court, the only issue on the preliminary injunction hearing today is about enforcement before June 21st, 2022. That is the date in the law that we are talking about, that the General Assembly said enforcement should begin. So we're not even talking about the substantive underlying law. We're talking about defendants' unconstitutional premature enforcement of this law on a date before the General Assembly has said it should be enforced. So that issue is a constitutional issue that cannot be addressed by the administrative court. As counsel just conceded, constitutional issues cannot be resolved in the administrative court. That's what makes going to administrative court a vain act. Moreover, plaintiffs did not ask this court to review defendant's decision on the variance request. It asked this court to prevent defendants from depriving plaintiff of its liberty and property interest in its license, the continuation of its business, the ability of its staff to continue in their professions without due process of law. That's the issue today, the premature enforcement that deprives plaintiff of these property interests. To the extent that defendants argue that all these interests are contingent on their variance decision, then the variance decision must be subject to due process constraints, but that's not plaintiff's issue. Plaintiff's issue is their property interest that is clearly at issue today, which is their license, the continuation of the business, and their ability of their staff to continue in their professions. Even if there were adequate remedies available for the constitutional violation in administrative court, which there are not, exhaustion of administrative remedies is not a jurisdictional requirement. There's nothing preventing this court from ruling on these constitutional issues and vindicating plaintiffs' constitutional rights today, and they should do so. Sorry, Your Honor, let me check one more thing in my notes. And defendants have conceded that the administrative court can't issue the relief defendants need. And there are multiple Ohio cases saying that when you're seeking an administrative remedy, it becomes a vain act when the court can't. And I believe defendants just said when the administrative court can't issue the relief that plaintiffs are seeking, then plaintiffs are not required to exhaust administrative remedies. And my final point, Your Honor, on the state court cases that have also looked at the variance requirements for abortion clinics, the state courts have said that the state courts have not reached the constitutional issues of the variance system. Repeatedly in cases defendants cite, and including the Capital Care case that defendants mentioned today, the court said they will not reach the constitutional issues because the only issue at administrative court is whether there's a variance or not. Thus, if the variance is denied for whatever reason, whether the defendant's actions violated the Constitution or not, the license will be revoked. That's what's happening here. The license will be revoked if this court does not stop defendants from taking these unconstitutional actions. So, Your Honor, that is why plaintiffs need relief today for this, for defendants' unconstitutional actions of premature enforcement of this law before June 21st, 2022, the date in the statute that the General Assembly has set for enforcement of this law.
Thank you. All right, I'm going to just take a brief recess and I'll be back with a decision. Okay, I believe we have everybody back. We're going to go back on the record. I have reviewed everything and listened to arguments today, and I do agree with the plaintiff in this matter in that the state cannot enforce a law that has not yet taken effect. So the court also finds that venue is appropriate and proper before this court. So the court will grant plaintiff's request for a preliminary injunction. And that preliminary injunction will stand until June 21st of 2022, when the law takes effect, specifically the amendment to Senate Bill 157. Is there anything else before we adjourn?
A couple of housekeeping matters, Your Honor. Defendants filed a motion to dismiss, or in the alternative, a motion for summary judgment against Planned Parenthood on March 26th. The parties have agreed to extend the deadline for the opposition to May 9th.
All right, well, let's go ahead and I guess set some dates for scheduling. So we'll go ahead and we can go off the record for just those dates and things. Okay.